Welcome to the session Information Technology Act 2000. In this session, we are going to discuss about the overview and objectives of Information Technology Act 2000, digital signatures and electronic governance, regulation of certifying authorities, cyber offences and penalties, adjudication and cyber appellate tribunal, amendments and recent developments. With the invent of computer technology and integration of internet, as good as multiple new things emerging, it also gave scope for certain threats. When we look at the evolution of computers, initially we saw some threats like virus or other issues. But the moment computer data was available on the cyberspace, it gave scope for many people to misuse the data. And there weren't much laws to protect these threats or security issues. So every government and the countries in which the computers were used for personal or business purpose started facing new type of security and other threats. So this required mandatory regulations. Now the governments of the respective countries started designing cyber laws. Most of the cases there weren't much law in place. In 1990s, as the computers emerged and integrated with the internet technology, there also emerged multiple cyber crimes. To regulate these crimes, Information Technology Acts were formulated. So new laws were framed for internet and other communication technologies. Now let us look into the Information Technology Act in detail. The Information Technology Act 2000 was formulated and endorsed. It was approved by the Parliament, by the regulatory authorities and put into practice since October 17, 2000. The law applies to all of India and any crime committed on the computer network located in India or by the citizen of India or the crime committed in the Indian geography using the computer or communication technologies. Now let us look into the need for Information Technology Act. The main purpose of the information technology was to provide security for the information, provide security for intellectual property rights and also provide privacy for confidentiality information and also to provide legal status for online transactions. Now this was not limited only for individuals. The law was also applicable for e-commerce and employers. This means the law was also be applied for organization and certain regulations were supposed to be imposed by the employers within the organizational premises. Now let us look into some of the salient features of Information Technology Act 2000. The Information Technology Act 2000 covers cyber crimes and electronic commerce in India. Some of the main objectives of IT Act are providing legal recognition, that is give legal validity to electronic records and digital signatures. It also covers cyber crime by defining and punishing certain cyber crimes with penalties, to regulate the cyber activity, to also look into the electronic governance, that is covering the electronic communications between the citizens, employers and the government, to provide data protection by establishing a legal framework with sensitive electronic data, also to promote innovation and entrepreneurship in IT sector. Though the formulation of Information Technology Act started sometime around 2000s, it took many years for the Indian government to look into the progress of the Act. Necessary amendments were made as and when new threats emerged. Even today, the government has certain limitations when it comes to establishing or making new amendments. The reason is the speed of growth of internet is much faster than what we assumed. So there are new threats which are emerging every day and this is causing a big problem for the government to frame new policies. In the first place, there were law which was framed for other offences. But when it came something like internet or information communicated over internet channel using electronic media, there weren't much regulations or other law framework which was existing. The base for the Information Technology Act 2000 was the United Nations UNICITRAL model. We took multiple quotes from the UNICITRAL and formulated our own Information Technology Act in 2000, which was applicable for the Indian scenario. Now let us look into certain amendments of Information Technology Act. The Information Technology Act Amendment of 2008 specifies the modification to Section 66A, which outlines the penalties for sharing offensive messages electronically. This includes any message or information that incited, hated or compromised the integrity and security of the nation. However, the lack of clarity in defining offensive messages led to unnecessary punishment of several individuals, ultimately resulting in the striking down of the section. Now, in 2008, there were still reformations occurring, and it took few more years for the body to analyze and understand the new threats and crimes occurring on the internet media. There were continuous amendments which were required, but it always takes time for implementing the new amendments. So the next amendment was in 2015. So the Information Technology Act 2015 made an amendment on 66A with the aim of safeguarding the fundamental rights guaranteed to citizens by the country's constitution. This was later accomplished by declaring it as violative of Article 19 of the Constitution. The initial number of sections in the Information Technology Act were limited, but today there are as good as 90 plus sections in the Information Technology Act. Now all these sections provide multiple regulations and security framework for employers, individuals who are using electronic media and exchanging information through internet. One of the major implications was digital signatures under Information Technology Act. The Information Technology Act 2000 includes provision that introduces the use of digital signature for submitting crucial documents online, ensuring their security and authenticity. The Act further mandates all companies or LLPs under the MCA 21 e-governance program to utilize digital signatures for document filing. Now this only means that the data which is transacted, if accompanied by the digital signature, tells that the data is more secured and it needs to be kept within the distributed framework. So you usually see a disclaimer or a digital signature accompanied at the end of an email or a note or an electronic media what is communicated. And some more amendments of 2008 were made on Section 66A and 69A. Section 66A changed the section that punished the sending of offensive messages, and 69A gave the government the power to block websites for national security. Now, a digital signature in particular is a mathematical technique used to validate the authenticity and integrity of a digital document, message or software. It is a type of electronic signature algorithmically routinely used to validate the authenticity and integrity of a message. So the message could be an email or a credit card transaction or a digital document. Now let us try to also understand electronic signature. Now an electronic signature is a short form of a normal signature what we used to do. Like at the end of the document when we put a signature, it is more like an authentication. Similarly, an electronic signature was put at the end of the document. It could be the normal signature which is just scanned and imprinted as an image or as a particular picture on the document. An electronic signature is an efficient and legal way to get electronic documents signed quickly. Secure and trusted around the world, e-signatures can replace an handwritten signature in many processes. Now let us try to see the difference between the electronic signature and the digital signature quickly. Now in the diagram what you see, an electronic signature can be enabled by an individual by doing the settings on security properties. So we see like, okay, signed by so and so, it is enabled. So what happens there? The electronic signature is already embedded on the document. So this is an example for the email digital signature. Now this image gives us more clarity about the difference between electronic signature and the digital signature. The digital signature is more secure, while the electronic signature is just like a signature embedded, a digitally copy of the signature is embedded on the document, while the digital signature requires permission and authentication to open the document. So the image very clearly indicates that the digital signature is more secure. Now let us also try to look at the difference between the digital signature and electronic signature. A digital signature secures the document while electronic signature verifies the document. A digital signature is authorized and regulated by the cyber appellate, while electronic signature can be generated and used by anybody, so it doesn't require the endorsement of cyber appellate, comprised of more security features, while electronic signature is less security. And common types of digital signatures are based on Adobe and Microsoft, while electronic signatures could be like, verbal and signature, checkbox and others. Digital signatures can be verified, electronic signatures cannot be verified. Digital signature is preferred more than electronic signature due to high level of authenticity and security, while electronic signature is easy to use but it is less authentic. Digital signature is particularly concerned about securing the document, while electronic signature is showing that a sign of contract or agreement. So having understood the digital signatures and electronic signatures, we can agree that digital signatures are having higher power and more security. Let us move forward to understand the cyber appellate tribunal. Now we needed a body or an authenticate set of people who would look into these cyber laws. And for the purpose, the Information Technology Act 2000 also formulated a body constituting set of members who were experts not only in terms of information technology terminologies and the set of progress happening in the IT field. There were also the people who were representing the law, like who were coming under the law jurisdiction. A cyber adjudication is purely civil in nature and the adjudicating officer has the power to hold an inquiry in the manner prescribed. Cyber adjudicating office is equivalent to the civil court exclusively to handle the contravention under Information Technology Act. Now, a cyber appellate tribunal was formed constituting a key set of people. It was formulated under Section 49. The Cyber Appellate Tribunal is a single person body known as the presiding officer of the Cyber Appellate Tribunal. So these people would look into the cyber laws, so they were empowered to make necessary implications or put penalties on the cyber crimes. Now let us look into the cyber offences. Cyber offences could belong to any of these things like hacking, identity theft and impersonation, publishing obscene material, cyber terrorism, data theft and unauthorized access. We can see all these falling under section 66, 67 and 66 under various clauses. Now to understand more of what is a cyber offense, any type of criminal activity conducted over internet media can be considered as a cyber offense. To be specific, a cyber offense according to Information Technology Act 2000 could include hacking offense under section 66, which is unauthorized access, damage or disruption of computer systems or networks. The second one is identity theft under section 66C, fraudulently using someone's password, digital signature or biometric data. Cheating by personation under 66D, where it could be an online fraud, impersonation, phishing or fraud using electronic means, cyber terrorism. Now, cyber terrorism varies from one country to another country, so India has particular regulations. Offense, cyber activities threatening sovereignty, integrity, security or friendly relations of India. Publishing obscene material. This could be at individual level or at the group level. Offense, publishing, transmitting or storing obscene, sexually explicit or child pornographic content. Data theft and unauthorized access under section 43 and 43A. So the offense is unauthorized downloading, copying or extracting data from a system. Sending offensive messages, that was under section 66A. So this was again struck down by Supreme Court in 2015 amendment. Failure to protect personal data under section 72A. Disclosure of personal data without consent leading to wrongful loss or gain. Punishment for intermediaries, like under section 79, intermediaries could mean social media platforms, internet service providers or any liable for third party content if they comply with due diligence and government regulations. Now, at individual level, if somebody is committing crime, the individual will be made responsible. But if it is an employee or a crime committed within the organizational premises, the employer needs to own responsibility of these privacy or security issues. Hence, there are also certain law which is being framed and followed by certain companies when an employee is given an opportunity to transact or use the electronic media. So employers these days also have set of regulations including the Information Technology Act codes under their provisions. Today, when we look into the number of crimes happening, there are equally more number of crimes happening at individual level compared to the organizational premises. The reason is organizations have laid a clear-cut policies on regulatory measures on misuse of information technology or information within the organizational premises. Most of these offenses could be related to the individual level or client level or misuse of data. Now, when such offenses occur, the organizations would look into the matter and punish the employee. It could result in handling the employee by setting up the internal tribunal and taking actions from the employer's side. Now, if the offense happens at the individual level, then it is going to come under the purview of cyber law framed under Information Technology Acts based on the amendments made in the respective years. Now, one of the amendments, like the Finance Act of 2017, dissolved the Cyber Appellate Tribunal. All pending cases were transferred to TDSAT, that is Telecom Dispute Settlement and Appellate Tribunal. So, now, TDSAT handles cybercrime appeals, telecom disputes and media regulations. Now, when Information Technology Act provides certain benefits, it also has certain limitations. Let us look into the advantages and disadvantages of Information Technology Act. While the IT Act of 2000 offers numerous benefits, it also carries certain limitations. First, to explore more about the advantages. Before the act was enacted, emails, messages and other means of communications were not legally recognized. Now, with the introduction of IT Act 2000, electronic communications gained legal recognition. Now, with the imposing of digital signatures, there could be higher authentication and security. Corporations get statutory remedies in the event of unauthorized access of hacking into their computer systems or networks. Individuals get monetary assistance or compensation as a remedy for damages of any kind incurred in computer systems. The Act further identifies and penalizes various cyber crimes such as hacking, spamming, identity theft, phishing, and so on. And this was not covered earlier by the legislation. The Act also permits companies to serve as certifying authorities and issue digital certificates. It empowers the Indian government to issue notices on the internet through e-governance. One of the amendments was from the recent years in 2022. Now, the amendment codes with a proposal to replace the Information Technology Act with a more comprehensive and updated Digital India Act. and this could cover a wider range of information technology issues and concerns, where the law could ostensibly have focal areas around privacy, social media regulation, regulation of over-the-top platforms, internet intermediaries, introducing additional contraventions or offences, and governance of new technologies. Since the Act was formed some 25 years ago, today here, when we look back 25 years ago, the laws and the set of regulations made in 2000 might not be relevant in 2025. So the government has to look into the new type of threats emerging, look into the new type of crimes emerging, and the government still has challenge in framing the act and making it evident for 2025. So the amendments are continuously occurring to support and provide more regulations to the information which has been exchanged on a new and a larger cyberspace. Today, e-commerce is another space where a lot of cybercrime possibilities are occurring. Fraudulent messages and misguiding informations could land up anybody into trouble. So there are new type of emergency response teams, like we call it as CERT-in, that is Indian Computer Emergency Response Team, are playing a major role in curbing the threats occurring on the cyberspace. E-commerce portals and channels have been given certain specifications to transact and protect the buyers or customers data, especially when it is involving the information exchange or financial exchange. So e-commerce companies have a bigger challenge and take the responsibility of protecting the data and other relevant information of their buyers, vendors, or any other stakeholders they are dealing with, and that becomes the major crucial responsibility for the e-commerce owners. Now let us look into the set of things what we discussed under Information Technology Act 2000. We started with understanding the objectives of IT Act 2000. We discussed about digital signatures and electronic governance, regulation of certifying authorities, cyber offences and penalties, adjudication and cyber appellate tribunal, what is their role we discussed, and amendments and recent developments in Information Technology Act, we discussed about these details. Now a quick set of interesting facts. And these are the references used for today's discussion. Thank you.